If you don't already know me, my name is Patrick McQueen. I'm a real estate attorney here in town. I've been doing this for 17 very long years. Our firm handles all sorts of transactional real estate matters, all sorts of litigation matters, both on the residential and on the commercial sides. And today, we're going to be talking about some of the things or some of the trends that we've been seeing on the property management side, and maybe forecast some where things are headed. Certainly, I always give out tips in these webinars, and so we're going to have a few tips as well that are helpful to you. And Clark already gave out probably the best tips is making sure you have the correct insurance. I mean, that's a lifesaver. So first of all, first thing that we're seeing and we're continuing to see, and by the way, I'm not going to put up my outline. I have a short outline. If you want my outline, just shoot me an email. I don't want to, sometimes when I put the outline up, it reduces the bandwidth and it slows things down a little bit. I've got a small brief outline. If you want it, just shoot me an email after this and I'll get it over to you. And frankly, shoot me an email if you want anything that we discuss. We're first going to talk about amendments. We're going to talk about evictions. We're going to talk about some new Supreme Court rulings. And then we're going to talk about some miscellaneous stuff. I'm an open book. You're more than welcome to have any of the stuff that I talk about, whether it's in a memo form, whether it's a form that might help you in connection with what you do. So please ask for it if you need something. But our first update is sort of looking backwards on what we saw in 2020. On the commercial property management side, our firm handled 81 lease terminations or lease amendments in 9 months last year. So 81 in 2020, in really just 9 months, 29 in 2019. And so we saw a fourfold increase in lease amendments to extend terms, to modify rent payments, to do all that stuff. And again, that's on the commercial side. We saw it mostly with gyms, restaurants, some retail, and now we're starting to see it with a little bit more on the office side. Some office managers are realizing that they're not wanting to come back, or they're not going to come back, at least not to the same extent. And so they're looking for options to get out of leases. And so, I think that's a trend that's going to continue into 2021, into early 2021 at least. And if you need forms, you've probably already been dealing with this quite a bit, but if you need more forms, let me know. Happy to get you that stuff, whether it's a lease termination, whether it's an amendment to a lease, etc. I thought that after the end of December in 2020, that maybe some of the lease amendments and lease terminations would go away, but we've seen an uptick in them again in thus far in February, and we saw them in January as well. I think some of that is people's New Year's resolutions. They realize that they might not be in a good spot, and they just say, "Look, I got to get out, and I want to get out." And so we've seen a lot of calls and lease terminations and lease amendments in early 2021. And again, hopefully, that dies off a little bit as the quarter progresses. Second big issue that we've seen or had to deal with are the evictions, and a lot of frustration in connection with residential evictions. Okay. Residential evictions were actually down last year. And sort of that's not necessarily intuitive, but it is because there were so many moratoriums last year. So year over year, residential evictions are actually down. Last year, you may recall, we started with the CARES Act. And the CARES Act basically stated that a landlord of a covered property was prohibited from doing two things. Those two things being, number one, evicting for the non-payment of rent, and number two, charging late fees or penalties for the non-payment of rent. And a covered property under the CARES Act was anybody or any landlord who had a federally insured or federally backed mortgage loan. So we started with the CARES Act. The CARES Act is largely gone as it pertains to evictions. It's expired. We also had Governor Ducey's 2 executive orders on evictions. Those were not true moratoriums. A lot of people thought that those were moratoriums. Those really weren't moratoriums. They did a little something different. Those have expired. We then had new Supreme Court rules for procedure and practice doing evictions, doing residential evictions. We had to have technological upgrades. We had to have new pleading requirements. We had to plead more things. And then there was a limitation on the number of evictions that could happen per hour in each of the courtrooms. So there's all sorts of new stuff that came out last year. Then we had in September the CDC moratorium. And interestingly enough, and this is where a lot of people were frustrated with the CDC moratorium, the stated goal by the CDC of the CDC moratorium that came out in September was to limit interstate travel. And so by virtue of creating this eviction moratorium, the thought was they could eliminate or slow down the transmission of COVID-19 by slowing down interstate travel. And a lot of people who have now sued the CDC are saying, well, there was much more better ways to reduce interstate travel than to shut down rentals or to make it more difficult to get rid of a tenant. So that's the basis for a lot of the fights against the CDC. There's been a lot of lawsuits here in Arizona and in other states against the CDC for having enacted the CDC moratorium, but we're sort of here dealing with the CDC moratorium. We got to deal with it as it's placed to us. The CDC moratorium, which is currently in effect, is different than the CARES Act moratorium. Under the CDC moratorium, they've broadly defined covered persons. Now, remember what I just said. When it came to the CARES Act, they defined covered properties. So there was a subset of people who were affected, of landlords who were affected. But under the CDC Act, it's much broader now. They've now defined covered persons. Okay, so it's covered persons. A covered person is anybody who signs that CDC hardship affidavit. And so it's much broader in scope. It's much deeper, and it affects much more people. There's civil and criminal penalties. And now that expires, that expires at the end of March. Could be extended, who knows? Rena had a question. The earlier email said the handouts were attached, but there's nothing attached. I'll get you that. I'll get you that. I didn't want to slow down any bandwidth by throwing up the attachments, but we can talk to WeServe and we'll make sure you get all the handouts. I have a ton of handouts. I have a ton of memos that you're more than welcome to have. So just let me know whatever it is you want and we'll get it to you. So what we have now are a lot of landlords, a lot of property managers who are completely frustrated. They want to know what they can do. And so we've come up with a list of about 7 things. I've got it in a memo. I've got it in a checklist that you're more than welcome to have. I'm going to go over a couple of these things right now. First is cash for keys. We saw this in the 2008, 2009, 2010 downturn where lenders were offering cash for keys. Well, now we have landlords offering cash for keys to just get rid of people. So that's number one. We've seen alternative payment arrangements being made. Alternative payment, I've seen people using the gift cards that they receive for Christmas or the holidays to pay rent. I've seen people doing work around the houses to pay the rent. We see people asking or receiving promissory notes and guarantees from other family members. So if you can get somebody else who's obligated, that's not a bad idea. So cash for keys, alternative forms of payment like gift cards if you have to, promissory notes so you can bind somebody else to that promise. A promissory note, a lot of people say, well, hey, I've already got this lease or I've already got this obligation that they've signed that says that they're obligated. Why would I need a promissory note? Well, promissory note is easier to sue on. It's a little bit easier to sue on and collect on than the true lease. And it basically is their reaffirmation that they owe the money as opposed to just relying on the lease. So people wonder why a promissory note would be helpful. Well, if you can get your tenant or a family member to sign that, that's not a bad thing. We've also seen relocations to other less expensive properties that the owners own. And then of course, evicting for other reasons, right? Anything other than the non-payment of rent, you're allowed to evict for. So if there's pets, there's unauthorized folks there, unauthorized people, if there's property damage. So we see a huge increase in the number of inspections going on to see if any of those things are occurring. So pets, people, property damage, the 3 Ps, you can still evict for those. And now, guys, here's the kicker. There's even more to this, okay? So now we have the CDC moratorium, which came out in September. It was recently extended. It was set to expire at the end of January. At the end of January, it was then extended now until the end of March. Who knows if it's going to be extended again? We don't know. Now the Arizona Supreme Court has gotten involved. And now the Arizona Supreme Court, as of last week, maybe some of you don't know about this yet or not, I don't know. And I'm happy to provide for you the order that the Supreme Court came out with. But they created an administrative order. And what the Supreme Court's role in all of this is to define the procedures by which you can evict somebody. And so they've now made it more difficult themselves to evict. So if the CDC moratorium wasn't enough, we now have a Supreme Court order that is binding on attorneys who try to evict or use eviction laws for on behalf of their clients or who participate in evictions. And this new Supreme Court rule or order requires a judge to make written findings of fact establishing non-compliance in a breach. So before, a judge wasn't obligated to do that. And before, we as attorneys weren't obligated to provide our proposed written findings of fact. Well, guess what? Now we do, okay? And that increases the costs associated with an eviction, all right? There's also, this is the other part that we found to be interesting. A part of the administrative order creates what's called an evidentiary presumption, okay? You know, like you're presumed innocent kind of thing. That's an evidentiary presumption. The other side has to come in with evidence that shows you're guilty beyond a reasonable doubt or by a preponderance of the evidence. Well, there's an evidentiary presumption now that the CDC moratorium automatically applies, okay? That's something that attorneys and landlords and property managers and property owners now have to overcome. So the courts have been instructed to sort of believe or take an evidentiary presumption that no matter what, the CDC moratorium applies and the eviction cannot happen, okay? So it makes evictions more expensive by requiring that attorneys come up with these written findings of fact that the court will hopefully adopt. The eviction hearings take longer now because you're asking the judge to adopt what you've said and you're showing the evidence to the court. And now you have a rebuttable presumption that the CDC moratorium automatically applies, okay? So they've added an additional wrinkle, and this came out last week. And so I wanted to make sure everybody was aware of that because now evictions just got a little bit more expensive. Frankly, I would say that on average, evictions became more expensive last year, probably twofold, maybe threefold. And I suspect that if you want to get an eviction done now, it's going to be even more expensive because now we have, as attorneys, we have to produce more work product, or you as a property manager or you as a landlord have to help produce, more paperwork. So a little bit of insult to injury if you're a landlord out there with some difficult tenants or non-paying tenants. Okay, so again, the two applicable doctrines or the two applicable issues that we're facing is the CDC moratorium, which is pretty strict, and now we've got the Arizona Supreme Court creating their own presumptions, creating their own obligations, creating their own evidentiary standards that we're stuck with, and there's really not much we can do except attempt to overcome them. Okay, so big issue number one is the commercial world. We're still seeing a lot of difficulty there. Big issue number two is we're still seeing a lot in terms of the evictions. If anybody needs or eviction issues, if anybody needs that court order, I think it's going to catch a lot of people by surprise. What happens to a holdover tenant? That's a great question. So somebody sent me a private message just now. What happens to a holdover tenant? Well, we've been making the argument, and we're going to continue to make the argument, and it was successful in 2020, that a holdover tenant is not even a tenant. They're a trespasser. And a lot of courts agreed with us in 2020. We suspect that that's going to continue to happen. And so what we're saying with holdovers is we're saying, look, there is no protection here. They're trespassers. There is no lease. They can't be covered tenants or covered properties or covered people or covered persons because there is no lease to begin with anymore. And so we've been pushing the issue. Courts have been very inconsistent on the issue of a holdover tenant, but we continue to push that issue, and we've been successful in pushing that issue. So that's a really good question. I actually have the analysis of right here. You can't see it because I've got a virtual background and I'm not good at doing the issue there, but I'm happy to get you this memo. So what we've done is, because we've had to come up with this holdover tenant issue or address this holdover tenant issue, our position is that the Supreme Court order doesn't apply to a situation like that. Our position is that the CDC moratorium doesn't work for them. And we've been successful in that. But I've heard of other folks in some instances that haven't been successful, and the courts are just saying, no, they're holdover tenants, they have rights, they can continue to stay there. I just disagree with that. And this to us is not a situation where a holdover tenant should have any rights. And so you issue the notice of non-renewal, they don't renew, or they're not allowed to renew. And if they continue, then we go through the eviction process. And again, we've been fairly successful in doing that. I don't know, we don't have any data points from either the CDC or the Arizona Supreme Court on whether a holdover tenant is protected by those things. But I think we have some pretty strong arguments that say a holdover tenant is not even a tenant anymore, and they're a trespasser. They have no recognizable or recognized possessory rights to the property, and therefore need to be evicted. So that's a great question that somebody came up with, and they put it in the private chat. But I can get you the memo. We've had to cite to a whole bunch of other cases and laws and all that stuff to define what it truly means to be a holdover tenant. And in this context, we don't think that the CDC applies. Again, as Clark said, though, judges are different. Judges have their own interpretations. Judges have their own set of beliefs. And we think we're right on this, but it really depends. We're not the ultimate decision maker in these situations. We can only position our clients the best we can. So great question there. So big issue number one, commercial stuff still happening, lots of amendments. Big issue number two is the eviction stuff that applies in multifamily context. It applies in the single family context. And again, I'm happy to get any of these memos. I'll throw in my contact information. I also have the written materials. I just, like I said, didn't want to put them up because I didn't want to drag down any bandwidth. The third set of issues that we've been dealing with, and this is an interesting one as well. I've now seen 4 different cases against property managers, based largely on negligence, negligent handling of COVID, negligent handling of guests. And one was in the single family residential context, one was in the commercial context, and then 2 were in the multifamily context. And these are lawsuits that have been brought against property managers for negligence. And the allegation is that, hey, I caught COVID, or my family member caught COVID because you didn't have proper cleaning protocols in place, or you allowed too many guests into the building, or you had improper guest protocols or guest screenings. And when I saw the first 2 of these, I go, there's no way that these are going to survive. This is just not happening. This just doesn't make any sense. And the reason I thought that is because, if you're proving that somebody was negligent, you have to prove that they caused your harm. And to prove causation, there is this causation element. If I'm injured and I have damages, I have to show that you were the cause of my harm. You were the cause of my damages. And so to me, I don't know how you could prove that the property manager was the one who was negligent and you caught COVID at the multifamily facility or the apartment complex or whatever it was, versus catching it when you went to the restaurant or the doctor's office or somewhere else. And so I thought that those cases would be immediately dismissed for lack of causation. You just can't plead causation, and you just can't make stuff up. Well, what happened in at least 3 of the 4 cases was that a doctor's affidavit comes in, and these doctors are paid to provide expert testimony, okay? And what these doctors have said is that this is the buzzword that they had to use. It is more likely than not that this person became ill based on their exposure at this building. Again, we're not testing the credibility of the doctors yet. We can't through this phase. But what the judges have said is, I'm going to at least allow this in as evidence and let people make the inferences or the determinations they need to make on the credibility of those statements. So to me, that's a pretty shocking result, is that you're allowing a paid expert to come in and say, well, this is more likely than not that this happened at this building, that this happened at this facility. and so these cases are continuing. I thought for sure they'd be dismissed. This is sort of the, what Clark mentioned at the beginning, and I just started shaking my head. You think it's going to go one way, and you've been doing this long enough, and then the courts just come out of left field and say, no, this is actually how we want to apply it in this particular instance. And so there's a potential issue there for property managers. And so, whenever we run into these issues of proper protocols and causation and that sort of stuff, or illness, we always recommend you have cleaning policies. We always recommend you have written maintenance policies, a written COVID-19 mitigation policy, written policy for guests that enter the building. Again, different buildings are going to need different things, but you have a plan for responding, and you have good signage about masks and no entering in the building if you are experiencing symptoms. And so these are the things that you're doing to satisfy the standard of care. So it becomes much more difficult for a doctor's affidavit to have any real merit. And so, again, having the cleaning policies, having, checklists, having those things in place, and sticking to them, right, are going to be the keys to avoiding liability there. So big issue number one, we're continuing to see property managers having to deal on the commercial side with a lot of amendments and negotiations and back and forth between landlords and tenants. Big issue number two are the residential evictions, which are tough right now for sure. And the Supreme Court of Arizona just made it a little bit tougher. Third are these cases that frankly, I didn't think had much merit at the beginning, and now apparently they do, which involve property managers and a failure of the standard of care and negligence. And then we started seeing these miscellaneous issues. These are a little bit more entertaining than true, true legal issues, but I'll bring them up. We're starting to see a lot of extra fees being charged or being put into leases, and it's fine if you can get away with it. I don't have any real significant objections to it. And now we've seen, giveaways for masks and stuff from apartment complexes, where previously they'd give you, one of those mouse pads or something with the apartment complex. Now they're giving away masks. It's amazing how things have changed. But those are the big four trends that we're seeing. Again, the commercial stuff, the residential stuff, the liability, and then kind of those miscellaneous things. And like I said, I'm happy to get you the Arizona Supreme Court administrative order. Again, I don't think that the administrative order necessarily gives tenants more rights than the CDC order already does, but it just makes an attorney's job a little bit more difficult, or a landlord's job more difficult. And if you fail to plead these items, or if you fail to ask for these items in the first place, guess what? Your eviction that may have been up here on the judge's list is now getting kicked to the bottom, and it's going to be much, much more difficult. So I don't know if anybody has any questions, but I'll put my information in the chat here, just in case you want that, any of those items that I mentioned, the memos, the Supreme Court, the recent Supreme Court order that addresses what it is you need to have in your pleadings, because to me those are pretty significant hurdles that you have to take care of them, otherwise you're going to get your case dismissed.
There was a question in the chat, Patrick, that was sent to me. It's from Rena. It says, are there free resources for landlords like there are for tenants to recoup rent through PPP? Here, let me put it in the chat. There you go.
Sorry, I don't know. Did I freeze there?
Mm-hmm.
Sorry. I didn't even hear it because it was freezing on my end.
Oh, that's okay. I posted it in the chat. Do you see it? It's a question.
About the handouts?
No, it says, are there free resources for landlords like there for tenants to recoup rent through PPP?
There are some resources. I can send you the memo on that. I don't get too deep into that because I let people just apply for those on their own, or suggest that they at least attempt to. So there are resources, and that's kind of one of the points of some of those lawsuits against the CDC is that, hey, you made these resources for landlords too difficult to obtain. You made them easy for the tenants to obtain, but now the landlords can't really obtain what they thought, or the money that was earmarked. So I have a list of those. Feel free to shoot me an email on those. But there are free resources, but I tell you, it is like it's very difficult to get them. It's almost like an urban legend that you can get some of those resources or get them taken care of for you. There's another question. It looks like I have a multi-dwelling with shared pay-per-use laundry room. Do I need to have COVID protocol posted? I would. I don't think it hurts. I think you ought to consider doing that, Barbara. I think that's probably a good idea, at least to put it out there and show that you've attempted to convince people to social distance or to wear masks while they're doing their laundry. And if you guys need something like that, if you need the notices or the postings or the policies, I've done a checklist. I previously sort of mocked, Burger King and McDonald's, on the back of their bathrooms. You go in a Burger King bathroom or wherever, a restaurant, it's got a checklist of when it was cleaned, who did it, what time, what they did, extra notes, whatever. I think that's, like I said, I previously mocked that as kind of an anecdote, but I think it's smart.
I don't see any more questions. Oh, there is one more.
So Mariana's got a really good question here. How do these laws and policies apply to short-term rentals? I think they apply. I think they apply equally. And I've previously provided a webinar. I don't know if it was on with WeServe or somebody else, about the risks associated with short-term rentals or the policies that you ought to comply with. The biggest two issues in the short-term rental context, frankly, if you're dealing with people, I think you need to have policies in place. If you're a regular buyer, seller, agent, I think you need to come up with your own set of policies that say, look, these are the people who ride in my car. These are the conditions under which they can ride in my car, or they can't ride in my car at all. I only do these types of showings, that sort of stuff, and stick with it. Same thing in the short-term rental context. The biggest two issues that came from COVID in the short-term rental context were the cleaning policy that said, these are the times in which we're going to clean. This is how we're going to clean. We're going to let it air out. We're going to do whatever. And so if you have that policy and you can show that your cleaners have stuck with that, then the likelihood of a doctor or some court saying that you did something wrong is much, much more minimized. As long as you're following with the CDC and local guidance, you're going to be fine. You still may be sued, but you're going to be fine. I can't imagine you would lose a situation like that unless you deviated from the system or your system was so far off of what the CDC was suggesting that those are going to be the only times that you get yourself in trouble. So there's a couple other questions it looks like now. If the moratorium is not extended past March 31st, will we be able to evict anyone who is in default for non-payment at that time? I think so, actually. I think so. I don't really see an impediment to that. Now, there may be something that comes out. It says, okay, well, the CDC moratorium is going away, but now you have to provide a 30-day notice before you want to evict and give some sort of grace period. At this point, I'm not aware that that's going, that's going to be part of the deal. But they may come out and say, all right, well, we're going to give this a little bit of a grace period. We're going to allow people to try to get caught back up. And if they can get caught back up, then you can't evict them. Maybe it's instead of a 5-day notice, you have to give them a 30-day notice under the CARES Act. That's what you had to do. So perhaps there's going to be some clarification on that, because I think the concern, and maybe this is where you're going with this, is that there's going to be a big surge of these hearings and of evictions, and that's probably true. So there may be some sort of further limitation by either the Arizona Supreme Court or somebody that comes out and says, well, this is the process you have to follow. I suspect that there'll be some clarifying guidance, but who knows? Is there a checklist for cleaning protocols we can provide our contractors? I can get you one. Rena, I can put my contact information back here, and if you want to send me an email, I can get you. I've got a pretty robust sort of document sheet. I don't know if you're referring to short-term rental situations or property management situations, but yeah, I think the cleaning protocols and providing them to all of your contractors and all of your employees, et cetera, is really the way to go. Short-term rentals, yeah. Rena, that's a great question. And so, yeah, I have I don't even know what you call it. It's a pretty comprehensive guidebook, not a book, but a PDF of short-term rental items that you really ought to consider providing to your cleaners, providing to your guests, that sort of stuff. Yeah, Airbnb has one on their site as well. And of course, CDC comes out with stuff all the time as well. But yeah, I think that would be helpful. So the two big issues, like I said, were the cancellation policy. A lot of people updated their cancellation policies due to COVID, and then the cleaning policies as well, because people don't want to get themselves into trouble like the property managers I described. Anything else?
Looks like there's one more question in there from Carrie.
Which one? Maybe I'm not seeing it.
Did you see it? You want me to?
Oh, about the memos?
About the squatters?
Oh, I don't see that one.
Oh, it's a direct message to me. That's why I'll say it.
Okay.
Sorry. It says, we are currently buying 3 rental properties that have squatters. There are no legal leases with the current owners. From what I understand, they have 0 rights to stay under state and CDC protection. Is this correct? Recommend course of action. Yeah,
in those situations, I would send the notice that they're trespassing, that there is no lease, and then try to evict. That's what we've been doing, and it's been working. But that's exactly what we're dealing with, is either somebody who's got an expired lease and there was a notice of non-renewal sent, and they're still thinking that the CDC moratorium applies. We've been successful in showing that no, that's trespass, and that there's no rights. The rights pertain to true tenants as opposed to squatters. Again, it really depends on what judge you get, unfortunately. But I would send a notice, 5-day notice, and try to get rid of them.
Okay, I think that's it from what I can see. There's a lot of questions. That was good.
There's a lot of stuff. It's tough right now. The leasing world, whether you're on the commercial side, the multifamily side, or single family side, it's just crazy.
All right. Well, thank you, Patrick, for your time, and thank you, Clark, for your sponsorship.
Happy New Year, and have a great weekend, everybody.
Yeah, thank you.
Right.
Take care.